Good morning. This is your Kelso Report for Friday, March 16th. I'm your host, Clark Kelso. Today we have cases dealing with Indian law, telecommunications, parole placements, health law, and attorney fees. We begin with a Ninth Circuit case involving an Indian law issue. In Salt River Project v. Lee, the Ninth Circuit held that the Ex parte Young doctrine applied in the context of an action for injunctive relief against officials of the Navajo Nation, where there was a suit to enjoin those officials from applying tribal law against the plaintiffs in a tribal court. The underlying dispute arose out of the plaintiff's operation of a power plant on tribal lands pursuant to a lease between the Navajo Nation and the plaintiff. The plaintiff had terminated 2 employees who were members of the Navajo Nation. The employees filed charges with the Office of Navajo Labor Relations, which issued a right-to-sue letter authorizing the employees to take their claim to the Navajo Nation Labor Commission. The plaintiff tried to defend on the ground that the Navajo Nation laws did not apply to their employment decisions because of provisions in the original lease and because a federally granted right-of-way extinguished all Indian uses of the covered land. The Commission rejected this defense, as did the Navajo Nation Supreme Court, which remanded the case to the Commission for proceedings on the merits. Well, at that point, the plaintiff filed an action for injunction in federal court, suing the relevant Navajo Nation officials, while not naming the Navajo Nation itself as a party, recognizing its sovereign immunity. The district court held that the Navajo Nation was an indispensable party and dismissed the action. But the Ninth Circuit reversed. It viewed the case as an ordinary application of Ex parte Young, where the Navajo Nation was not an indispensable party, and the Navajo Nation officials who were defendants would more than adequately represent the interests of the Navajo Nation. The Ninth Circuit remanded the case for further proceedings. The next case involves a telecommunications issue in Western Radio Services v. Quest. The Ninth Circuit resolved an interconnection dispute between 2 telecommunications companies. Quest was the local exchange carrier in a particular area. Under the Telecommunications Act of 1996, as the local exchange carrier in that area, it had an obligation to negotiate in good faith with other telecommunication carriers to give them access to the local exchange market. Under the Act, a carrier initiates negotiations with the local exchange carrier for an interconnection agreement. If the parties have difficulty reaching agreement, their dispute can be submitted to arbitration managed by a state's Utilities Commission. Ultimately, the Utilities Commission renders a decision about whether the agreement is consistent with the Act and approves or rejects the agreement. At that point, judicial review occurs in federal district court. Very interesting example of cooperative federalism. Well, Western Radio Services tried to raise 2 claims in federal courts. First, that Quest did not negotiate in good faith, and second, that the agreement that was ultimately reached was inconsistent with the Telecommunications Act. On the good faith claim, Western Radio had failed to present that claim to the Utilities Commission in a timely manner. And so the Ninth Circuit held that, as a matter of prudential jurisdiction, it would not entertain the good faith claim, since the Utilities Commission never got a chance to review that claim on its merits. As for the interconnection agreement itself, nearly all of the agreement was consistent with federal law, with one exception. The agreement treated as a non-local call, a call that originated within the local exchange, was routed through an interchange circuit, and then routed back into the local exchange where it terminated. The Ninth Circuit held the language of the Act clearly provided that a call which originates and terminates within a local exchange shall be treated as a local call, and the details of the routing are irrelevant to that determination. So Western Radio will at least get local rates for those type of local calls. Otherwise, it was a total victory for Quest. Now we turn to California Court of Appeals. First we have a case involving authority to make parole placements. Loren Herzog completed his sentence for voluntary manslaughter and accessory to 3 murders. Having completed his sentence, the California Department of Corrections and Rehabilitation had to find a suitable parole placement for him, which was complicated by the existing statutory restrictions on where he could live and overall public outcry regarding his placement anywhere in the state. Ultimately, he was moved to a trailer on CDCR's High Desert State Prison grounds in the county of Lassen, so he didn't move far when he was released. Nevertheless, the city of Susanville and the county of Lassen filed an action seeking writ of mandate to order the CDCR to remove him from the county. The local trial court ruled that his placement in Lassen County was not in the best interests of the public. What a surprise that was. And ordered the department to transfer him out of Lassen County forthwith. Well, in the city of Susanville versus CDCR, the 3rd District rather easily reversed. The applicable statutes vest exclusive discretion in CDCR to determine parole placements, and as the 3rd District noted, writs of mandate are supposed to be used to correct ministerial error, not to control an agency's discretion. Now, I think probably fortunately for everyone involved in this sad case, Mr. Herzog died while the appeal was pending, which gave the 3rd District the chance to set the law straight without immediately incurring the wrath of everyone in Lassen County. Next we have a health law case. Back in 2009, Governor Schwarzenegger exercised the discretion given him under federal Medicare regulations to opt California out of the Medicare reimbursement requirement that a certified registered nurse anesthetist be supervised by a physician. Federal law permits that opt-out so long as the governor concludes the opt-out is consistent with state law. Governor Schwarzenegger thought it was consistent with state law and went for the opt-out. Well, the California Society of Anesthesiologists and the California Medical Association, they of course challenged the opt-out with a petition for a writ of mandate. In California Society of Anesthesiologists versus Superior Court, the 1st District rejected the Society's petition. The applicable law, Business and Professions Code Section 2725, permits certified registered nurse anesthetists to administer anesthesia as ordered by a physician, and it nowhere suggests that physician supervision is required. It's permissive, nothing about a physician having to supervise. Now, of course, given the way things work in Sacramento, you can be sure that the next stop of the Society and the Medical Association will be the Capitol building, where the various lobbying interest groups will wage war over this little slice of the healthcare marketplace. My guess is that the legislature will reject any changes to the statute here because expanding the scope of practice of nurses is consistent with general trends in healthcare to find lower-cost resources to provide medical treatment. Requiring physician supervision would only increase the costs of administering anesthesia, and the legislature will be reluctant to move in that direction given all of the other pressures on healthcare costs. Finally, we have an attorney's fee case. The plaintiff in Walker versus T-Corp Title Company sued T-Corp and a number of other defendants, alleging a conspiracy to fraudulently induce the plaintiffs to take out real estate refinancing loans. The Superior Court granted partial summary judgment to, I think it's T-Corp, on a conspiracy claim, and a jury found in T-Corp's favor on breach of contract and breach of fiduciary duty claims. The contract contained a prevailing party attorney fees provision. However, the Superior Court did not award T-Corp its reasonable attorney's fees, instead reducing those fees substantially in light of the weak financial condition of the plaintiffs. T-Corp appealed, arguing that the Superior Court abused its discretion by taking the financial condition of the losing party into account in assessing attorney fees. The 1st District agreed with T-Corp. Now, there is some intermediate appellate authority for the proposition that when attorney fees are awarded by virtue of a statutory provision, one of the equitable considerations that a trial court may consider is the financial condition of the losing party. But the First District distinguished that authority by noting that the attorney fees in this case were awarded by virtue of a contractual provision. And, unlike statutory fees, contractual attorney fees are voluntarily incurred. Now, there is a bit of analytic tension between the First District's holding and the prior cases involving statutory awards of attorney's fees, because in California, even contractually authorized fees are technically awarded as a matter of statute, which suggests that the distinction drawn by the First District may be a bit contrary to the legislature's attempt to standardize the law regarding attorney fees. We will have to wait and see whether this tension is enough to interest the California Supreme Court in a petition for review. And that's it for today's Kelso Report. Have a good weekend and a great day in the law.